Welcome to another episode of Conduct Detrimental. Dan Lust, Dan Wallach. We are back again with a big sports law story. This time, Deshaun Watson settling 20 of 24 active civil cases. Lots to unpack. We'll see how it affects the disciplinary hearing moving forward. But before we get into it, Dan, let me kick it to you. Initial thoughts on this bombshell news.
Well, I mean, it was inevitable. We were all waiting for the eventual settlement. Unfortunately, it doesn't close the loop because it doesn't encompass all of the potential, or it doesn't encompass all 24 plaintiffs. And we don't know how many future litigants are going to emerge trying to leverage themselves into a better settlement. But at least we can finally begin the discussion about potential NFL discipline, with light at the end of the tunnel. Now it's not something a year from now or 2 years from now. It's going to be this summer.
So I'll try to catch everyone up as quickly as we can, but it's important as to when this timing comes. So Tony Buzbee has announced recently that there would be a 25th and a 26th lawsuit filed against Deshaun Watson. And he also mentioned that the Houston Texans would be added to these cases as a defendant based on what they knew or did know or didn't disclose. And on a previous episode, Dan, you and I spoke about this potential civil conspiracy cause of action that could be filed. So that's what was coming down the pike. So this settlement comes at a really interesting time. A, because of what I just said, because there's two developments that are supposed to come in litigation, but B, because we have long said that the NFL is intending to come to a decision on a suspension by the end of the summer. So, okay, put a pin in that for a second. This is interesting. The interesting number immediately that I thought of, there are 4 holdouts. So 20 of 24 active cases have been settled. It doesn't speak to, and that's the way they phrase this release. It doesn't speak to whether those 2 additional cases are going to be settled. It doesn't speak to whether the Texans contributed to the settlement or whether they're going to be brought into the case. So for all intents and purposes, I think we're still going to get a 25th and 26th case, and the Houston Texans are going to be brought in. Dan, before I go any further, is that your read on it as well?
Yeah, with one modification. I don't think the NFL is going to wait until the end of the summer, because then that's going to present, some real timing issues in terms of the disciplinary, in terms of the appeal of the disciplinary proceeding. During the summertime, they can schedule the appeal hearing, and the disciplinary officer can preside over an appeal at any point within 30 days after the turning over of evidence. But once you get into the NFL regular season, then the timing becomes much more complicated, and Article 46 of the collective bargaining agreement provides for some limited windows. It has to be on a particular Tuesday. It becomes a major bureaucratic nightmare to schedule anything during the regular season. So I would imagine if there's discipline coming at all, and there's 99.9% the other shoe's about to drop, I think it's going to happen sooner rather than later, and maybe even as early as before the end of June. But I think from the league's perspective, they need to leave at least 1 month to 6 weeks prior to the beginning of the regular season in order to shoehorn this hearing in without it spilling over into the NFL regular season and creating a major timing snafu under Article 46, because then scheduling becomes a major problem, and it interferes with the business of the league as well as with the Cleveland Browns team during the regular season. So it's got to happen sooner.
So quick, before we get back to it, I mean, the reports since we last recorded, the NFL plans to argue to disciplinary officer Sue L. Robinson for a significant suspension of Deshaun Watson. And then there's reports that the NFLPA is prepared to defend that vociferously and bring up, conduct from the owners. And I know, Dan, you want to talk about that. We'll leave it. But the other report that came out, just because we want to give everyone the news before we do the analysis, there are some rumblings, I'll call them rumblings, unsubstantiated rumors, that a 1-year suspension is on the table. Whether or not that was leaked out there so the NFL could judge people's response, I think the response was that might be fair. I mean, it's not necessarily me saying this, but I read a lot of the replies. I try to check out what the sentiment is. I think people did not think that was, or an overwhelming amount of people did not think that would be necessarily unfair. Again, this is still someone hasn't been convicted in a criminal court of anything. So if you were sitting on the side, and I know a lot of our listeners are, that says, hey, why is the guy being suspended for anything if a grand jury failed to indict him 2 grand juries? So I'm just reporting it. It was a report that was put out there by a lot of verifiable and reputable sources that a 1-year suspension is at least on the table. So Dan, I think where I wanted to, at least before we leave the background stuff here, 4 holdouts, right? That's by every stretch of the imagination of however many people that have filed suit, 4 do not want to settle. So back at last year's trade deadline, we've talked about this a bunch. There was at least a report that the Miami Dolphins were prepared to make a trade for Deshaun Watson, assuming all 22 of his cases could be settled. And what do you know, Dan? 18, and not those last 4, opted not to settle, and those were the holdouts. So I know I mentioned it to you. I think we're on the same page. So somebody asked me, I did a couple radio hits today, some in Cleveland, and someone asked me, do I think this was a good or a bad day for Deshaun Watson? So a good day that you could get 18 cases settled, but that was always seemingly on the table since last fall. So I'm not sure what necessarily changed. I would probably lean toward this being a sign of bad news for Deshaun Watson, that there are 4 people here. Deshaun Watson has $230 million guaranteed, and we'll talk a little bit about whether that deal could be voided and whatnot. But he's got a lot of money, and there seem to be 4 people out there that are not concerned with the money. They're concerned with having this case continue and having their day in court to tell their truth, to speak their piece, have their day, and have maybe a Johnny Depp, Amber Heard-esque courtroom at some point in time. That's my read, that 4 people do not care about money here. They just want to put Deshaun Watson's feet to the fire. That's my read on the situation.
Yeah, my read on the situation is it is about the money. It's just about more money, right? There's going to come a point in time in which every plaintiff is going to settle a case like this. And the notion that they're going to get their Johnny Depp versus Amber Heard moment on court TV is ludicrous, because a case involving alleged sexual misconduct, sexual violence is not going to be televised. No trial judge, given the sensitivities and protecting the identity of, not protecting the identity, but protecting the dignity of sexual assault victims. I don't think this is a case that's going to end up on court television. And at some point, Deshaun Watson's attorneys are going to reach a number that's going to be satisfactory to the other side, or if Texas has a version of Florida's offer of judgment statute, you can tender a settlement proposal of a certain dollar amount, and then if it's not accepted, and then the plaintiff recovers, significantly less than that, then that will impose a burden on the plaintiff to pay Deshaun Watson's attorney's fees for not accepting a bona fide settlement.
Yeah, New York has that as well. I'm not sure if Texas has it. We should probably look that up. But Dan,
go ahead. But I think ultimately, to answer the question of why is the NFL going to proceed here when the grand jury decided not to indict, when there was no criminal aspect to this case. And I think if we've learned anything from the Ray Rice, Tom Brady, Adrian Peterson, Ezekiel Elliott, up and down the line, a successful criminal prosecution or even the existence of a criminal investigation is no bar to the NFL's consideration of its own discipline for the same alleged misconduct because of the burden of proof. In a criminal setting, you need proof beyond a reasonable doubt in order to convict somebody of an offense under the United States Constitution, but it doesn't work that way in the NFL's justice system. The standard of proof in the personal conduct policy is simply credible evidence of the violation of the personal conduct policy, and a suspension can be upheld if there is any credible evidence to support it, even if it's outweighed by other evidence. That's about the lowest threshold there is in the law. So it's not inconsistent to have no criminal prosecution yet still have discipline under the NFL. They can both be true, and they're not in disharmony with one another, given how disparate the burdens of proof are.
Listen, we can follow that all. I think the other point that we should talk about, right, is a point that a lot of people in my replies have been saying for the better part of a year. Why doesn't Deshaun Watson just settle all of these cases? Won't that make his problems go away? And Dan, we should bury it, right? Like, there are these cases, right? These 17, it's a 17-month period that carries over between 2020 and 2021. That's the New York Times report with these 66 different masseuses. So the statute of limitations has not run on this entire window of time. So, I did the math on another show. It was
two years? Is it 2 years?
I believe it's 2 years.
Yeah.
But if it's Dan, 18 individuals that have provided statements in support of Deshaun Watson, right? And now there's 26 individuals that have shown we'll say a willingness to file suit. That's 44, right? I'm just doing some rough math here. And if there's 66 masseuses, that tells you that as many as 22, if that New York Times reporting is right, could still file suit. So this was the problem that we talked about in the last show, that Deshaun Watson could settle all the active cases, and there's still no guarantee against future litigation because Deshaun Watson doesn't seem to know how many masseuses he dealt with. They asked him at the press conference, does that number sound right? 66 in a 17-month period. And he said, I'm not sure. Speaking to my lawyers, I'm not sure that adds up. But unless he, again, kept some type of like detailed Excel spreadsheet of every time he had a massage, which would be crazy in its own right, he's not going to have that information. So, yeah, I think he took a calculated risk. Let's just eliminate some of these, eliminate the potential that more people are going to go on HBO Sports. Let's hammer this out. So, yeah, I think it was a calculated risk. But I think that at this stage of the case, I don't think it's going to hurt Watson. Unless, Dan, I have this question for you, which I didn't mean I had on my list for you. Do you remember when Roger Goodell last year, at the end of last year, he said, we don't have enough to suspend Watson and put him on the commissioner's exempt list? Do you remember when he said that?
I know he said that, but I don't know if he really meant it because the bar is so low. But go ahead. He has enough to suspend him, if that's your question.
Well, the question is now, do you think that his settlement and whatever the confidential terms, I'm sure there was some money involved. Reportedly, $100,000 was offered to each plaintiff once upon a time. Do you think this will, in any event, maybe increase the punishment? Right? It's not admission of guilt. Never a settlement or release agreement will never admit to any type of fault. But do you think the NFL could view it as such and maybe enhance the punishment because he's essentially paying these women something, even though he'd always said outwardly, "I'm fighting for my truth. I never planned to settle these," and lo and behold, he does settle them.
No, it's not going to be a punishment enhancer. What it will do is act almost, psychologically as a corroboration of all these charges, because the NFL has already conducted its own investigation. They've interviewed a number of the alleged victims. They've interviewed Deshaun Watson. All they need is any credible evidence. They've already got it. They've got the testimony of a number of, even one, if 1 out of 24 witnesses is credible, the NFL can suspend Deshaun Watson. I think what the settlement does is kind of accelerate the timeline on the decision-making for the NFL. An enhancer or a multiplier would be if you commit a second or third or fourth act of alleged violence, which violates the personal conduct policy. And that raises another question. If you've got 24 instances of alleged sexual misconduct, that's like each one can act as a multiplier. Like if you can serve 6 games for one incident, and then the second incident can result in a lifetime ban. I think the NFL has plenty of ammunition now with 20 settlement agreements to utilize a multiplier to make his discipline worse, because now it's multiple offenses, not just a single offense, which differentiates this from Elliott, Peterson, Brady, and all those other cases where it's just one incident.
Yeah, I mean, the other thing that we should hit on, I know we've spoken in the past, when you're saying each one could act as a multiplier, there's also the fear that I would think, if I'm Deshaun Watson, that we saw it happen, right? The complaints said a certain code of conduct. The deposition at some point, months and maybe a year down the road, someone repeated the allegations in the complaint, and that set off a separate, chain of news. So somebody asked me, they're like, could Deshaun Watson be suspended again after the suspension? So you could talk about, Dan, each one being a multiplier, maybe more women popping up after the fact. But I think a realistic scenario is that there is a second wave of really negative media attention if this does go to trial. If there are those 4 holdouts that just want their day in court. And Dan, I'll disagree with you respectfully. The Amber Heard Johnny Depp case, I watched a lot of it. A lot of it dealt with some really ugly, whatever you want to call it, sexual assault, or there was some really messy and ugly allegations to it. So we have in our recent history a judge, obviously different jurisdiction across the country, in Virginia, being willing to have that case in front of court. And sometimes judges just like a case in front of them for the media attention. So if a judge wanted this case in front of them, it certainly wouldn't shock me. And then, Dan, to end the point, if at a trial, right, you had someone give very powerful testimony, one of these 4 holdouts, or maybe even the 25th and 26th that haven't yet filed their cases, some really powerful testimony that are even testifying to things that had already, come out in deposition, in the complaint. It's not going to shock me if there's another wave of people saying, a year from now, we should suspend Watson more. He didn't get enough. He only got 8 games or 10 games. He should get more. So I actually think that's a scenario people should be paying attention to.
Well, I don't know if we're going to have a perpetually open door here for time immemorial, because there's a 2-year statute of limitations, and he saw these alleged, 66 massage therapists over a 17-month period. At some point, that window is going to slam shut, and it could be December, 2020, 2 years forward. So there might be another 6 to 9 months of potential plaintiffs, which means that's his element of risk here, that there could be more plaintiffs emerging at some point between now and then the end of the 2-year statute of limitations period. He's probably about 3/4 of the way through it based upon the timelines from some of these complaints. But I think we need to, if possible, we should talk about the process under which he's going to be held to account by the National Football League. You ready to talk about how the CBA works and some of the deadlines and timelines and basically what the trial is going to look like? Because I think that's the inevitable next step in the saga of Deshaun Watson, and it's going to come to a head fairly quickly. July, August. I think there's going to be some discipline rendered this summer, and an appeal proceeding conducted under the aegis of this collective bargaining agreement. And this is all going to move forward at some point this week. So, Dan, to lead things off, I think the first step in the process is Roger Goodell has to render his discipline. Now, one of the changes between the old CBA and the new CBA is that now we have a disciplinary officer that will hear, that will make the initial disciplinary determination. The NFL will make a recommendation, and that recommendation will be, suspend or not to suspend. But unlike past CBAs and past alleged offenses where Goodell was, quote unquote, the judge, jury, and executioner, we now have a new individual by the name of Sue Robinson, who is the NFL's disciplinary officer. She's a partner at a law firm in Delaware by the name of Farnham LLC, and she's serving a 2-year term as the NFL's disciplinary officer for Article 46 proceedings. And what a first case to have. If you're Sue Robinson, she's a former federal judge who obviously is well-versed on evidentiary standards. You're going to be having a federal judge, a former federal judge, decide on Deshaun Watson's discipline, rather than have Roger Goodell sort of make it up in a vacuum and, apply whatever standards and have inconsistency with some of his prior punishments.
Yeah, but my understanding then is if that either side wants to appeal her decision, that it goes back to Goodell, right?
That's right, but he can't overturn the liability finding. The only ground for appeal is modification on the amount of discipline, not whether discipline itself was justified. So if, for example, Judge Robinson finds that Deshaun Watson didn't violate the personal conduct policy, that's it. Case is over. The NFL can't appeal that determination. They could potentially try to take it to a federal district court judge to vacate the arbitration ruling, but they're not going to do that. If there is a disciplinary decision and there's a finite number of games imposed as a suspension, that amount is subject to an appeal, and Roger Goodell can decide whether to modify the suspension or to leave it intact. But he can only shorten or potentially lengthen the number of games to be served. He can't overrule the judge's determination on the merits as to whether there was a violation of the personal conduct policy.
So hypothetically, Dan, and this is a point that I find of interest, right? There is the civil and criminal statute of limitations, but as far as I know, right, the NFL is not necessarily bound by those strict amount of years, right? Let's say, again, we could deal in hypotheticals. It's a podcast here. If 2-3 years down the road, right? Or let's say 5 years down the road, we'll say the 27th or 28th person comes out and they allege a different version of events than these women's. Maybe it's more heinous act. They didn't want to come forward, but they tell that to the NFL. I'm not aware, Dan, you can tell me if I'm wrong. I'm not aware of anything preventing the NFL from saying like the door is closed on all further type of suspensions for Watson. I would always be nervous if I'm Deshaun Watson that someone is going to come out in my past that wasn't accounted for in this initial round of settlement, wasn't accounted for in the criminal complaints or the civil cases, and the NFL could issue some type of suspension. I believe that's on the table.
He should be fearful of that. I mean, that's legitimately a possibility. I mean, with every massage therapists coming forward in the future, that's a separate offense. That's a new offense. Even if it involves the identical conduct, it doesn't have to be a different kind or more heinous form of misconduct. It could fit the parallel of the 25 prior cases or 24 prior cases, and Roger Goodell will be well within his right to impose a new round of discipline for the same conduct during the same time period, because it's a different victim. It would be like Ezekiel Elliott, having a second alleged assault against a different victim. That would be not only grounds for a new round of discipline, but it could enhance the prior discipline and potentially leave Deshaun Watson vulnerable to a lifetime suspension under the personal conduct policy.
Right. And just if you want to talk Ezekiel Elliott, I know we want to stay within football, but Trevor Bauer, right, his suspension, at least the rumor mill would lead you to believe that he was suspended for some old conduct that wasn't really related to this the San Diego accuser. We spent a lot of time with it. So, Dan, even if a case is brought outside of the statute of limitations, right, I would be nervous if I'm Deshaun Watson. It doesn't matter if you're the NFL.
There's no statute of limitations in the National Football League. I mean, it's not a prosecution.
But probably for good reason, right? Because if you did something in your past, something bad, and it comes out, there's undisputed evidence, whatnot. The NFL is a private entity. They're not bound by the civil or criminal statute of limitations. So that's the fear if you're Watson. And if I'm Watson's attorneys, I would be very, on edge about Watson's response. I've said it, on the show, I'll say it on, on other shows, like that he doesn't really know if that number 66 masseuses in 17-month period sounds right, because, he's dealing with DMs, he's dealing with massage shop owners, he's dealing with, I'm sure some form, I don't know this for sure, but I imagine Venmo and digital payments. He can't triangulate all these different massages that he did. So he has no idea, right? So I would be very fearful if I'm Rusty Hardin by saying, or even like an Adam Schefter, right? And I went on our show and I talked about it. Adam Schefter at one point had a kind of ill-advised tweet. He said, the truth has come out. And that was after the grand juries failed to indict Deshaun Watson. It doesn't mean that the truth has come out. There's 66 women involved here. If anything, right, if there's no indictment with respect to the handful of criminal complaints, I believe it was 10, I don't know, it doesn't speak to the other 56 women involved here. Obviously, not all of them are bringing charges, but again, there's just so many loose ends here that if you're the Cleveland Browns, and I don't know, I think I'd be very surprised, and truthfully, if the Browns knew everything that we know today, right, that they willingly agreed to give him $230 million. Either they didn't do their due diligence, or they have a risk tolerance of someone I've never heard of in the history of humanity. It just seems very, very odd.
Yeah, the Cleveland Browns aren't going to have a snowball's chance in hell of invalidating this contract. I mean, he already had 20, some odd cases pending. The NFL had conducted an investigation. The Browns shouldn't have been surprised that there was the possibility of additional litigation being filed, and they're not going to be able to get out of this contract. They've already tendered the draft pick compensation to the Houston Texans, and the signing bonus is earned. There's no way that the Browns can claw back a signing bonus, which under the collective bargaining agreement is deemed to be earned when the contract is signed, subject to very limited exceptions, such as the player holding out or not having his services available because he's incarcerated, not because he's suspended. So the signing bonus portion of Deshaun Watson's contract is sacrosanct. Now, of course, further discipline and being unavailable to play in NFL games could end up having the effect of voiding certain guarantees under Watson's contract. But to the extent he's been promised a signing bonus, and I think of the $230 million some odd dollar value contract, all of which is guaranteed, 40 or so million of it is in the form of the signing bonus. So he's already earned that money. That can't be taken away from him for time immemorial unless he goes to jail, which isn't happening.
Well, I would bet that it's not happening. I don't think we can say with a black letter that it's not. But I'm with you that if I'm betting on it, that's what I would say. The other thing I wanted to add, I don't really have that much more in this. I think we've hit this so many times over the last year and a half. I think we should remember, even if the Browns could attempt to void the contract, right? At the end of the day, you have a certain question as to whether the Browns will, because they parted with 3 first-round picks here. They could void the contract and potentially get out from under that $230 million, but then they'll be left without those 3 first-round picks. So again, I would think that the Browns have made their bed, right? And they have to kind of lie in it, so to speak. The Browns are wed to Watson. If they have to face a 1-year suspension, I don't know, 2 year suspension, that they kind of have to eat it because they've lost those draft picks. Unless some facts come out here, the Texans were really dishonest or just lied about what they know or didn't know, and then that's a separate story. But we'll see.
Well, there's always Baker Mayfield. There's always Baker Mayfield to fall back on, or you can tank for the next great number one overall draft pick. So maybe it's not the worst thing in the world for the Cleveland Browns to ultimately have Watson, but also have a high level draft pick for the 2023 NFL draft. But before we begin to write Deshaun Watson's NFL obituary, we have to remember that he's missed an entire season under this amorphous, being sidelined with pay while this investigation was going on. And the notion that the NFL could suspend him for more than 8 games, let's talk about even a full season. When the dust settles on that, you're talking about a player in the prime of his career being suspended, or the equivalent of being suspended, for 2 full NFL seasons in a profession where most people only have, at least at the quarterback position, barely play over 10 years. I mean, he's going to be losing more than 20 or potentially 20% of his career over civil allegations that never rose to the level of a criminal indictment and never were tried in a criminal forum, and are just purely civil lawsuits brought by an attorney who has somehow miraculously had 24 separate individuals come into his office, all looking for representation on the same nucleus of operative facts, the same offense. Clearly, there's a little bit of a coordinated effort here by plaintiff's counsel to gin up this litigation, to hold it over Watson's head, to extort or extract, or maybe it's extract or extort, the most favorable settlement possible. But at the end of the day, Dan, the notion that Deshaun Watson is going to be forced to sit out for 2 years while Robert Kraft engages in basically the same conduct and gets nothing, absolutely nothing. Jerry Jones oversees this awful situation with sexual misconduct by one of his high-ranking employees and has some of his own recent incidents. He gets nothing. And then let's not leave out the one and only Dan Snyder, who oversaw the Animal House of NFL football teams, a multi-year systemic endemic environment that has led to a congressional hearing over a toxic workplace environment. And all he gets is he gets a little bit of a, he gets to hand the team to his wife while he's still conducting NFL related business. So it's 0 games, 0 games, 0 games, yet Watson is going to face 32 games. And the notion that you can have this disparate discipline, remember, all of the personnel in the National Football League, whether they be owners, players, trainers, general managers, punters, wedge men, publicists, they're all bound by the NFL's personal conduct policy because they're all held to a higher standard. And if they're all held to that standard, you can't have disparate punishment. And I think, as I've highlighted on Twitter, I've gone to the law library here, and I looked up some of the past decisions from former Commissioner Paul Tagliabue in Bountygate and former federal judge Barbara Jones in the Ray Rice arbitration. And both those decisions highlight the importance of having fair and consistent discipline. And disparate discipline is clearly a defense that Deshaun Watson would be able to raise, and maybe even have a very strong case of proving that, based upon the fact that the other owners got 0, he got 32, and look no further than Tagliabue's decision, where he set aside some of the discipline because in past instances, the discipline was imposed as a monetary fine against the teams without any suspensions against the players. So whoever I think Sue Robinson, this federal judge, is going to look very closely about how the NFL has treated other owners involving similar incidents.
So, you know what I'm curious about, Dan, and we'll see if we ever hear it, but Deshaun Watson didn't play for the entirety of the 2021 season. So if they are thinking about a 1-year suspension, will that be viewed in the eyes of Sue Robinson or the NFLPA or the NFL as a de facto 2-year suspension, right? And I think the question is, which I think is a fair question to ask the Texans, if they knew, right, and there's an allegation that they knew more than they were letting on, they gave him these NDAs we spoke about in the last the last long form episode we did on this. So if the Texans, knew this, maybe that's why they weren't playing him, because they said, hey, like, if we punish the guy, we give the guy some type of suspension, we're not going to get as much of a return for our asset. So I think there's some hard-hitting questions to ask the Texans here. I do. And I think, I read the statement from the NFL PR that today's settlement has no bearing on the type of discipline they're going to ensue. But I would think behind the scenes, I think the NFL probably would like all of these cases to get settled. You know why, Dan? Because that would, in all likelihood, end the Houston Texans involvement. So certainly you could have some, potential cross claims or whatever you want to call it that survive. But that's only to the extent that the Texans get brought into the case. So if all of these cases were settled before the Texans get brought in, and somehow Tony Buzbee, it's funny. Like Dan, I was about to say, if Tony Buzbee agrees not to file any more lawsuits, but the truth is, Dan, like, I think some of these cases are getting referred to Tony Buzbee. I know there was some out-of-state lawyers that referred him, at least one of the new cases that came in. Tony Buzbee seems to be the gatekeeper of these cases, but you can't have some type of settlement agreement that says that Tony Buzbee is not allowed to file any more lawsuits. And even if there were, Dan, any other lawyer could file a lawsuit. So I'd still be concerned, Dan, that once the suspension is written, once some type of discipline comes in, that there's more cases to be filed, because now, and we should talk about this, now I think people have some estimation of what the price tag is. If Deshaun Watson plaintiff, the fact that number 100,000 got leaked, that wasn't a Rusty Hardin leak. That was a Tony Buzbee leak. I think it was in one of the complaints that was filed. If I'm one of the other 20 women in this case, I would say, hey, maybe I'd lose some credibility by filing so late in the case. But I'll take a shot. I'll take a shot at getting $100,000. So I still think that's going to happen here. So it's a decision that Sue Robinson is going to have to deal with. Roger Goodell. Yeah. The fact that more information could come out after the book is written, I think. I don't want to bear the lead here. I think that's the real fear here.
Well, listen, if Tony Buzbee is involved, first of all, he's in all likelihood, if there are going to be additional plaintiffs, he's going to be their attorney, or at least he's going to be behind it. And if he's entering into negotiations with Rusty Hardin, there's got to be some kind of good faith here, where you put all your cards on the table. And if he's aware of any other potential prospective lawsuits where he's representing somebody and they just haven't filed yet, and he doesn't disclose that during settlement negotiations, I think that's going to look awfully bad. And it's going to be a fact that's favorable for Deshaun Watson if and when he's potentially subject to further discipline down the road by the NFL, because I think Tony Buzbee, for all of his reputation and given how he's perceived in some corners as a little bit of an ambulance chaser who's trying to gin up some publicity, I think if he holds back information that he knows as part of these settlement discussions, I'd want a representation and warranty from him. I don't know if he'd be a party to the settlement agreement, but if I was Watson's attorney, I would say, look, I want one representation from Tony Buzbee that he's not aware of any other potential victims that might file suit, or, you'd want to have some open and candid discussion about that. I wouldn't sign a settlement agreement without knowing or having some kind of warranty from that lawyer that the next shoe is not about to drop tomorrow. So I don't think that would be too much of an ask, but I think Watson could be in very good hands with Sue Robinson, and here's why. Having a federal judge preside as a disciplinary officer, that's something that's going to ensure Deshaun Watson something that Tom Brady and Ezekiel Elliott lacked in their disciplinary proceedings. They had to fight to get evidence like witness transcripts, being able to cross-examine Jeffrey Pash in the Deflategate case. Sue Robinson works for Farnan LLP, and I interviewed with Joseph Farnan Jr. about 30 years ago when I was interviewing for federal judicial clerkships, and Joe Farnan was one of the judges that I was gunning for. And in my entire lifetime, I've never met anybody who had such a fidelity to the rules of evidence. They were like sacrosanct for him. And I would imagine that anyone in his firm, particularly a former federal judge, is going to be obedient to procedural fairness, fundamental fairness, rules of evidence. And under the CBA, the NFL's got to now share these transcripts and all of their evidence. They're not going to be able to rely on things that they don't share with the Players Association. So unlike all those other player discipline cases, Peterson, Watson, Elliott, we're now in a new collective bargaining agreement, and one of the few victories, and there were hardly any victories in that CBA for the players, but one of the few concessions that DeMaurice Smith was able to get was A, an independent a disciplinary officer, and B, a guaranteed exchange of evidence. And so I think the playing field is going to be much more level for the player in the post-20 CBA than it was in the pre-20 CBA. And then from a favoritism or a home cooking perspective, I've got one final point. Judge Robinson is a sort of a byproduct of the Delaware legal system. She was a federal judge in the District of Delaware. Delaware has had a long period of acrimony with the National Football League over issues like sports betting, and there's almost like this historic, deep-seated sort of contentiousness between the NFL and the Delaware, legislative system and legal system, where I think, unlike the Second Circuit and the Southern District of New York, I'm not so certain that a judge who's the byproduct of the Delaware legal system is going to put her thumb on the scale in favor of the NFL. And given some of the, previous fights over sports betting, I think Watson would be very happy to have a former Delaware federal judge oversee the case. At the very least, he's going to be guaranteed a level playing field when it comes to evidentiary issues.
Dan, I think that's a good place to end the conversation. We've certainly flagged a bunch of these issues. Reminder, our podcast is sponsored by Themis Bar Review, top bar prep company in the galaxy. We've been talking a lot about potentially employment issues, collective bargaining agreements. Head over to themisbar.com/condetrimental, and you can drop a note if you're interested. We can always tell you why Themis is the best. We do promote Themis a lot, not because they like us, but because we actually think they're the best bar prep company. Dan, as we got 30 seconds before I got to run, but I think we flag our listeners. We are paying very close attention to the Roger Goodell testimony in the Washington Commanders case. By the time some of you listen to this, the hearing will have already been heard. Dan and you and I are planning a special, we'll call it a Manning cast, like Eli and Peyton do the Monday Night Football. We're doing a conduct cast or a Dan cast, whatever sounds better, but we're going to have the hearing feed live on Twitter. We're going to tweet the link out, and you guys can watch along with us live. And then I think we're going to put the audio, if it goes well, we're going to put the audio in our podcast feed so you can listen to it. But it's our first time trying it, so
a big if it goes well. If it goes well, we have a couple of mystery guests lined up. I don't want to tease them in advance because they may or may not show up, but we might have some interesting conversations and some very well-known guests, coming into our clubhouse to comment on the congressional hearing and Roger Goodell's testimony in real time. We expect the hearing to last a few hours, and no truth to the rumor that Dan Snyder is our mystery guest.
No truth to that rumor. Okay, Dan, I think it's a good part to end this. We will certainly have more coverage of this case, NFL cases, and all things sports law on Conduct Detrimental. For Dan, myself, the Conduct Detrimental family, we will see you next time on another episode of Conduct Detrimental.